Well, good evening, everybody. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Tonight, we have Jim Slaughter and Ian Roberts with us to talk about the essentials of condominium and HOA management. So excited to have you all with us. We're lucky to have Jim. This is his first time presenting. He is a parliamentarian, an author, and a CCAL member. And Jim, you may talk in a minute about your honorary position that you're going to be getting here in a couple of weeks out in Vegas. But as a reminder, we do record these sessions, and we do encourage you to share this information with your other board members, and that can be found at camsmgt.com on the webinars page. If you do have questions, please feel free to use the Q&A feature at the bottom of the website or bottom of the page, and I will help facilitate those questions at the appropriate time through the webinar. So, Jim, I will turn it over to you. Thank you again.
Thank you, Ben. Welcome, everybody, to Essentials of HOAs and Condos, what you need to know as a board member. In this world all the time, I really sincerely want to thank you all for being board members. It is a big deal. I mean, you are the governing body for the association. It's also an honor because it means that the members of the association felt like you were the one that should be responsible for the association's assets and taking care of the rules. By the way, did anybody mention you might get sued? You might regularly be insulted. With that in mind, I was asked to come today and talk about what do you need to know as a board member. Specifically, we're gonna talk a little bit about what's the difference between an HOA and a condo. Not really going to talk about cooperatives, but it's good to know what you might live in because they're a little bit different. We're going to talk a little bit about governing documents. We're going to talk about some board duties. We're going to talk about legislative update because this is likely going to be one of the busier legislative sessions, and there will likely be some changes that will impact how you do things as a director. And finally, going to give you a number of resources so that if we don't touch on stuff today, it's not that long. If we don't touch on things today, you'll have a chance to go to other places and find information. Ian and I are here today from Law Firm Carolinas. Ben asked me to say just a moment about us. Law Firm Carolinas has the largest HOA condo practice in the Carolinas. We have offices in both states. We do this all the time with every imaginable kind of association. We do have clients all the way from Murphy, which is right on the border in the west, to Manteo, all the way in the east. Many of you are our clients. I will mention, just because I have to give it as a disclaimer, if you are not one of our associations, first, that's hurtful. But secondly, we aren't giving legal advice today. Instead, we're going to talk about a number of areas, and we're going to talk about some general things. But just the nature of this type of presentation is it can't be legal advice because we don't have all the facts about any particular question or information. In terms of our firm, again, we do this all the time, and it may range from collection of assessments to helping draft document amendments to answering questions about emotional support animals and fair housing laws, anything that associations do. I am past president of the National College of HOA Condo Attorneys. Harmony Taylor in our firm is also a fellow in the College of Community Association Lawyers. She is the current chair of the North Carolina Legislative Action Committee that watches HOA condo legislation in North Carolina. And David Wilson in our firm, one of our partners, is the South Carolina chair of the Legislative Action Committee. So the end result, as you can tell, is we just do this all the time. We really enjoy this practice. We're happy to talk about any particular topics. With that in mind, let's get started. Hate to talk about a little bit of policy and philosophy of associations, but it kind of needs to be done because different ones of you are in different types of associations, and it matters. There are two main types of community associations. I'm going to say community association several times tonight. Ben may say that. Community association is the umbrella term for the different types of community associations. There are really three. We're not really going to talk about the cooperatives because there just aren't that many in North Carolina. They're a big thing up north. In North Carolina, you're likely to see a homeowners association or a condominium association, and it's going to be split even among the people that are watching this. Without getting too much into the philosophy, in a homeowners association, you as an owner own your lot. You own all of the lot. You own everything up into the sky. You own everything down in the ground all the way to the middle of the earth. and everything on that lot is yours. It's your private property. By belonging to an association, there's a document called a declaration of covenants, conditions, and restrictions, sometimes called the CCRs, and it formed the association. And basically, it tells you what your rights and responsibilities are. Generally, the way it works in an association is you own your lot, and then an association owns all of the common area. That might be a sewer system, might be some sidewalks, it might be some roads, could be a pool in some communities, might be some other things in other communities. But the common area is owned by the association. And then as a member, you pay assessments and you have the right to vote within the association on things that come up for a vote. In a condominium, different animal. In a condominium, you only own the inside of your unit. Everything outside the unit belongs to all of the members together. Everybody owns a percentage interest. And it gets weird. So I'll just mention this. If you live in a condo, it gets weird because it tends to be that your assessments, your dues, as well as your votes are usually measured based on the percentage size of your particular unit. So if your particular unit is 1.75 of the entire condominium, you probably pay 1.75 of the assessments. And when you go to vote on things, you probably have 1.75 votes. It just depends on what the documents say. Difference between the two, again, is in an HOA, you absolutely own your property and then you belong to an association. Condominium is a little bit different. You just own the inside of your unit. Everything else is owned by all of the owners in common. And then the association has control over the property. It's good to keep them different. It's good to distinguish between what kind you're in because the laws are different. The rules are different. The power is different. If you even think about it, you sometimes have to wonder whose property does something belong to. And we're going to get into that with governing documents. There are a bunch of governing documents and associations. And as a board member, I'm not saying you have to read every single word of every single one of these, but you do need to at least know they exist and you should page through them. That's one of your responsibilities as a board member. Without putting you completely to sleep, there is this thing called the declaration. It is the highest governing document within the association. There are statutes, we're going to talk about that, but the declaration is what created the association. And again, it's sometimes called the declaration, it's sometimes called the covenants, it's sometimes called the CCRs, it's sometimes called the Declaration of Covenants, Conditions, and Restrictions, which is where the CCRs comes from. And it's sometimes called a declaration of condominium if you're in a condominium. It's filed with the Register of Deeds. Amendments to it have to be filed with the Register of Deeds. And when I say it's the highest document, it not only tells all of the owners what they can do, it tells them what they cannot do. If you're going to tell an owner what they can and cannot do on their own property, it's normally got to be in the declaration. Rental restrictions, declaration. Pets on leashes, declaration. Certain animals not allowed, declaration. Have to pay money for something, declaration. Usually the declaration is where we look to find what people can and cannot do on their own property. There's this other document. You've probably never looked at it, but you should. It's called the Articles of Incorporation. It's a corporate document. It gets filed with the Secretary of State's office. It's what creates the nonprofit corporation. You don't have to be a nonprofit corporation if you're a condominium, but you do need to be a nonprofit corporation if you're an HOA. Almost all associations are nonprofits because it gives certain protections. If your association has an Inc. at the end of it, Happy Homeowners Association, Inc., it means you're a nonprofit corporation. This document is filed with the Secretary of State's office. You can probably pull it up, depending on how old your association is, at the Secretary of State's website. The reason I say you ought to look at it is because people are sometimes surprised by what's in it. These days, articles of incorporation only tend to have the name of the corporation, who's the purpose of the corporation, a few items like the original initial directors, and maybe some indemnification language. But sometimes we will see in articles of incorporation, how many directors are there supposed to be? How long are director terms? What month is the annual meeting supposed to be held in? The articles of incorporation are actually a higher document than the bylaws. So it's good to know if there's something in there you need to care about. Next, bylaws. Bylaws are a governance document. Bylaws are supposed to tell you how to run the association. And so it doesn't get into things like whether or not you can have dogs or cats or sheep on your lot. Instead, it deals with things like, when is the annual meeting? What can you do at the annual meeting? How many directors are there? How do they get elected? How many officers are there? What are their duties? What's the parliamentary authority for the association? It has to do with the day in, day out running of the governance of the association. So another good document for you to take a look at. And finally, board policy. Board policy is a document that is adopted by the board of directors. And in North Carolina, and I'm going to ask Ian in a second to tell us how it's different in South Carolina. In North Carolina, board policy always tends to be a document governing the common area. What I mean by that is the association in an HOA owns and a condominium controls the common area. So if the board wants to adopt a rule that says all animals on the common area in the park must be on a leash, that would be a board policy. It can be adopted by the board because the board controls the corporation owns this common area. If you want rules for the pool, it'd be the same. No alcohol at the pool. Everybody's got to have alcohol at the pool. Whatever your policy might be, the board can adopt that, and those do not tend to be filed, except it's a little different in South Carolina. So Ian, tell us what's different in South Carolina about these documents.
Yeah, absolutely. So board policies in South Carolina, kind of like Jim was talking, very commonly are going to refer to common area or property that the association owns, because they're allowed to make the rules on, just like Jim was saying. That being said, it's also very important, and you're going to hear this probably quite a few times from me, to read your documents, read your declaration, your master deed if it's a condo in South Carolina, because there are some times when the board is granted powers through those documents to create policies for other items that deal with stuff outside of the common area. For example, the declaration may, authorize finding and say that the association can fine homeowners for violations of the declaration. And it can also contain language that says a policy for finding can be adopted by the board. You cannot make a policy if there's not that kind of a language in the declaration. So it's very important to see what exactly is allowed in the big three documents: the declaration, the articles, and the bylaws. But unlike North Carolina, in order for any document or anything to be enforceable in South Carolina, it has to be recorded with the Register of Deeds of the applicable county. So unlike North Carolina, where the bylaws or the board policy may not need to be recorded, if there is something that a policy the board passes, or any of the information in the bylaws that can be enforceable on homeowners, in order to do that and take any kind of enforcement measures, they have to be recorded with the Register of Deeds website, or else it's kind of like having teeth but not being able to do anything about it.
Hey, Jim, two questions that came in relevant to the last two slides. One, where does a townhome association fall in your first description of condo and HOA?
Excellent question. And I should have touched on that, but I was moving us along. I'm going to go back up. People wonder where are townhomes. See, we've got our homeowner associations, we've got our condominium associations. And again, we could spend 5 hours talking about a couple of these slides. There is no statute in North Carolina that refers to homeowners associations, because in North Carolina, the statute refers to HOAs as planned communities. Planned communities. So if you ever hear Planned Community Act, planned communities, that's homeowners. Then they're condominiums. Townhomes are HOAs. Townhomes are planned communities. They can look like anything, but the difference, and why are they different than an HOA or a condominium? In a townhome, you actually own your physical piece of land, meaning there's a perimeter to your lot, and you own everything up into the sky above your townhome, everything, including the roof. You also own everything below your townhome, the foundation, all the way into the ground to the center of the earth. So why does the association have anything to do with that? Well, because there's this contract called the declaration, and the declaration for a townhome tends to divvy out responsibility. For instance, it might say that even though the homeowner owns their roof, the association is responsible for maintaining, repairing, replacing the roof. Or, very common in townhomes, the association is responsible for maintaining the exterior of the townhomes, the exterior building surface, as we sometimes say. So townhomes are considered planned communities under the Act.
So other question relevant to the slide right now is where do rules and regulations fall in the 4 items on the next slide?
Rules and regulations are board policy, and they all use the same term. Board policy, rules, regulations, that tends to be, not always, because sometimes people label things wrong, but if it's a rule and regulation adopted by the board, it's a board policy. And again, boards tend to only be able to occasionally interpret things that are vague when the documents give them authority to do it under a rule and regulation, or, and this is more common, the board can adopt rules and regulations governing the common area. So again, if there's any common area, like if they're private streets, the board could adopt rules regarding who can park, where they can park, very different than public roads, and that's because it's common area. And so it just depends. By the way, I didn't brag on Ian enough a few minutes ago, I realized, and that is Ian used to be a community manager. So he managed communities in Florida, decided he loved that so much and just couldn't get enough of this stuff that he went to law school. And now Ian is licensed in North Carolina, South Carolina, and Tennessee. So if for some reason somebody has a Tennessee HOA question tonight too, Ian is your guy. So as we move on, and I want to get through some of this initial stuff because you need to know it, but my gosh, it'll make your eyes roll up into the backs of your heads. As directors, just be aware, there are a lot of laws that govern associations, more than we could talk about tonight. There's federal law. There are federal laws dealing with collections of assessments, dues, lots of them. There are federal fair housing laws as to how people are treated within the community. There are disability laws. We're often asked about the Americans with Disabilities Act or with various issues related to handicapped access. Most things in associations fall under the Fair Housing Act. And so you're more likely to hear us talk about that. There are state statutes galore. And by that, I mean, we could spend all day on state statutes because I'm not going to, but depending on where you live, they're up to like 4 different statutes that we have to at least look at that could apply to your association. And if you've contacted us with a question, and I know the managers do this, we usually ask, what type of association is it? Planned community, condominium. When was it created? How many lots are in the association? And the reason we're doing that is to figure out which statute it falls under. There is a North Carolina Unit Ownership Act, 47A. What's that? Well, that has to do with old condominiums. These are condominiums that were created prior to October 1, 1986, and they fall under a thing called the Unit Ownership Act. Effective October 1, 1986, the North Carolina Condominium Act took effect. It applies in full to every condominium created in North Carolina with a declaration being filed on or after October 1, 1986. Well, in their wisdom, the General Assembly said, wait a minute, some of these statutes are so important, they ought to apply to everybody. The statutes dealing with collecting assessments, the statutes dealing with going after people for violations of the documents, the statutes regarding meetings should apply to everybody. And so those statutes were made retroactive. So those and some other ones apply to every association whenever created, but generally the North Carolina Condominium Act only applies in full to condominiums created on or after October 1, 1986. As I mentioned earlier, there's a North Carolina Planned Community Act. That's the one that governs homeowners associations. It only applies in full to homeowners associations that were created by the filing of a declaration on or after January 1, 1999. And you have to have at least 21 lots or it doesn't apply to you. Older associations, smaller associations can adopt the act, but it only automatically applies if you've got at least 21 lots and you were created by the filing of a declaration on or after January 1, 1999. But yet again, some of it was made retroactive. The provisions regarding collecting assessments, the provisions regarding going after people for violations of the governing documents, and the provisions regarding meetings apply to everybody whenever they were created. On our website, we have guides to each of the acts. We also have the full acts on our website, and we've put in bold the provisions that apply to all associations. And so I'll either tell you how to get those, or Ben and CAMS will send out an email and say, here are some resources that we talked about. Isn't that enough? No, it's not. And that's because if your association is a North Carolina nonprofit, there's a whole nother set of statutes that apply if you can't find your answer in one of the documents we've already talked about. The North Carolina Nonprofit Act fills in the gaps for anything that is a nonprofit corporation. It's in Chapter 55A. It deals a lot with meetings and virtual meetings and calling meetings and electronic voting and things like that. And so sometimes we have to go to it. The nice thing for those of you in South Carolina is it's not quite this complicated. So Ian, can you tell us what they need to worry about?
Need to worry about your documents. The declaration, the bylaws, the articles, board policies, rules, and regulations. South Carolina does have some statutes, but they're not as developed as the ones in North Carolina, or from my past life, the ones that were available in the state of Florida. They don't cover a whole lot of information, and I'd say probably 90, if not more % of the time, what's going to need to take place is going to be found in your governing documents, your declaration, your bylaws, your articles, your board policies, rules, and regulations that you create. That being said, there are a few statutes. There is the South Carolina Homeowner Association Act. There's the South Carolina Horizontal Property Act, which is for condominiums. And there's the South Carolina Nonprofit Corporation that does have some information that can be, Nonprofit Corporation Act that does have some information that can be helpful, particularly if you're in an association that maybe the governing documents weren't drafted with as much information in them as you see in a lot of associations nowadays. Perhaps it's an older association, or it was just a smaller association at the time that has kind of grown. But typically what you're going to be finding in those acts is you're going to find some quorum requirements in the event that your documents say something different, disclosure information. There's also the Homeowner Association Act in South Carolina developed the Consumer Affairs Department, which allows homeowners to basically file complaints if there's any kind of issues going on in their particular association. But overall, when looking through the actual statutes that are in place right now in South Carolina, you're not going to get a whole lot of in-depth answers out of them for particular situations that you have to deal with. A lot of that is still going to be most of that's going to be coming from your actual governing documents and potentially case law in the event that any sort of situation gets to the point where it has to be litigated. There are actually a lot of judges in South Carolina who are hoping that some issues get pushed through their courts a little bit more, so that there can be some more hard, fast rules that would answer some better questions more than you see in the North Carolina statutes and all of that.
This, as you can tell, is a lot of statutes. Do you need to memorize all these? Who would want to be a director if you had to memorize all these? A theme you will hear multiple times tonight, and I'm going to go ahead and say it now. I'm going to say it again. Listen to your manager. Listen to your community manager. We regularly talk in our firm about how the laws regarding HOAs and condos, whether it's federal or state or even local ordinances were on that slide. That tends to deal with noise ordinances and animals running around a community. The laws regarding HOAs and condos seem to change more often than almost any other area of practice that we see in any other field. It's impossible to keep up with all of this unless you follow it all the time. And that's one of the benefits of a good community manager. They live with this stuff. They know how things are supposed to be done. The managers at CAMS see this kind of stuff. And just as importantly, they know when you need to get somebody else involved. They know when to bring us in and get an attorney's advice on a particular thing. But one of the main advantages of a community manager is they can keep up with all this stuff. If I were an association on a board, I would not want to do that without a professional community manager, because they do this stuff day in and day out. They've got the forms and they know how to do stuff. So wanted to tell you about these statutes, but don't feel like you've got to go online and start memorizing all of these, because that would convince you very quickly that you do not want to be on the board of directors. A little bit of advice on director duties. That when it comes down to it, and again, as I said earlier, I can't give legal advice except in North Carolina. Ian can give it in South Carolina. This is nonprofit law. Going to touch on it, not going to spend a lot of time on it. But in terms of what your duties are, you can kind of boil them down to three things. One, As a director and a board of directors, you're supposed to follow the laws. There are a lot of laws, as I mentioned. You're supposed to make certain that the laws are followed and that the association does nothing that is in violation of the law. You're supposed to collect the assessments owed by owners. Assessments, the word in the statutes, you may call them dues. That's the only money the association has. The association has obligations. It might be stormwater. It might be paying for landscaping. It might be paying for various bills like water, sewer, electricity, and condos. Things that will get turned off if they are not paid. The only way that gets paid is by collection of assessments from owners. And finally, your duty is to enforce the documents, whether it's the declaration or the bylaws or the rules and regulations. You will hear from Ian, you will hear from me regularly. We always advise, follow your documents or change your documents. You can change your documents. The members have the right to do that. But if you don't change the documents, follow the documents, because as attorneys, we can't say, oh, just ignore the documents. We say follow the documents or change the documents. When you boil down how you're supposed to do that, and Ian then at the end of this can say whether or not it's any different in South Carolina, but I don't believe so. Directors are supposed to do their jobs in good faith and with due care. And I'm not going to get into legal 501 because we don't need to spend that time today talking on this. But what it boils down to is a couple of things. You as a director, the directors run the association. We're going to hit on this later. Individual directors don't run the association. Directors run the association by meeting with enough people present and voting on things. But by voting on things, that the philosophy of a homeowners association or condominium association is that members elect the board. Members can change the documents. So if you think about it, ultimate authority rests with the homeowners or with the owners, with the members, because they can decide who the board is and they can change all the documents. But between meetings of the members, the association board runs the association. It governs the association. As the governing body, directors are supposed to exercise their job in legal terms, good faith, due care. Good faith just means as a director, you're supposed to always do what's best for the association. If you're thinking, we need more money, but that means I'm going to have to pay more. I really don't want to pay more, so I think I'm going to vote again. No. As a director and with your director's hat on, you always have to do what is in the best interest of the association. This neighbor of mine that is a friend of mine is doing something in violation of the documents, but I don't really want to go after Charlie. I mean, Charlie's a friend. Maybe we will ignore it. No. You always have to do what's the best thing for the association. You have to follow the documents. You have to do what's best for the association. In fact, if you have an interest that is different than other owners, if we're talking about entering into a contract with your daughter's landscape company, you're supposed to abstain and not be involved in the discussion or the vote. If you have a personal money interest in a vote, if you have a personal interest in a vote, you're supposed to not be involved in that particular decision. You can also run into trouble if you're in a master association. And a master association means you might belong to a smaller association with a bigger association. Sometimes members will serve on two boards. They'll serve on a board of this association and that association. Realize that can set up a conflict of interest, because if there's any dispute between the sub-association and the master association and you're on the board of both, that's a conflict of interest and you really should stay out of the fight. At the end of the day, board members are what are called fiduciaries. All that means is you're like the trust officer at a bank. You're supposed to watch the interests of the association far better than you watch your own interests. Everything you do is supposed to be in the best interest of the association. And if you can't do that, you should not be on the board of directors. Due care. Due care means you're supposed to follow the governing documents. As I said, get a copy, kind of peruse them, look at them, get a little familiar with what's out there. And you as a director are supposed to follow the governing documents. You have a duty to inquire, meaning that if you're going to make a decision on something, you're supposed to find out enough information that you know what the heck you're voting on. But there is this thing that you have the right to trust your professionals. So that the law actually allows you to listen to your lawyer, to listen to your community manager, to listen to your accountant, that it's okay. You can inquire, but you're also allowed to trust your professionals. And finally, one of the duties of due care, is that there are things you will talk about as a board that are confidential, and you need to keep them confidential. These tend to be things like legal advice. You should not share legal advice to the board with anybody unless it's agreed that it's okay. You will at times talk about who's not paying their dues, their assessments. That tends to be confidential because it could be horribly embarrassing for it to get out that somebody has not paid their assessments. And if someone's lot is in violation of the documents, that should be confidential too. So if you're in closed session, you discuss something as the board that is confidential, you really are supposed to keep that confidential from everybody. And that means neighbors, friends, even your spouse. You're not supposed to talk about confidential information that deals with the association with anybody. Ian, any difference with those nonprofit requirements in South Carolina?
Nope, Jim, you actually hit that right on the head there. The big three that we typically in South Carolina explain to board members who potentially maybe have not been on the board before and don't know what exactly is expected of them, what they can and cannot do is, as Jim said, good faith, as the ordinary person would do, and in the best interest of the association. Those are the big three that you're looking for if you're serving on the board and what you're overall expected to do. That being said, as somebody who has lived in HOAs, managed HOAs, and now represents HOAs, it's very common, every now and then there is a board member who, when they get their spot on the board, they maybe think that they have all this power, and that can be an issue throughout the association. The ultimate goal is to have the association be as cordial and amicable and happy as possible. That's what everybody wants in a dream scenario when it comes to an HOA. That being said, when a board member tries to overstep those the responsibilities they're allowed to have and what they're actually allowed to do is when issues can arise. So I did just want to touch on real quick before I go back to Jim, a few things that a board member cannot do or a board cannot do on their own. And that is, as Jim was talking about, you can't amend the governing documents on your own. That's going to require a vote of the association because at the end of the day, the members are the ones who are living by the rules. The board members are also members of the association, but it impacts everybody as a whole. So the board cannot go by themselves and make new rules unless they're, of course, in a board policy that's allowed to be done for common area purposes, but they can't change fine policies or anything like that without the actual authority granted to them in the declaration. The board also can't shut down the association on their own. That prevents, anybody from joining the board and potentially just being like, okay, the whole reason I was on here was so that we can shut this down because I'm tired of paying dues every year. Board members also cannot elect new board members themselves. That vote is going to have to be done by the membership of a whole of the entire association. The board can't just continuously make the same members nonstop and just choose who's going to serve on the board. That's going to take some input from the other members of the association. And the board can also not determine qualifications that are not specifically laid out in the governing documents for people who can serve on the board. You can't say you have to have, 3 green hats in your closet in order to serve on the board of directors of this association. All that kind of stuff is going to have to require some sort of a membership vote in order to make sure that it's not just being run by the select few who are on the board. You, of course, as board members, have a lot of responsibility and powers that you have to take considerable care with and make sure that you're doing everything properly. But at the end of the day, the whole point of this is to make the association as the best that it absolutely can be, which goes back to the good faith and doing everything in the best interest of the association.
Thank you, Ian. How do you protect yourself as a director? This will be about the most legal sounding slide you're going to get. So I'm not going to spend time on it. There is a thing called the business judgment rule. The business judgment rule just basically says that board members tend to be protected if you make a decision at a meeting at which a quorum was present and you didn't have a personal interest in the decision. And it was within the scope of authority that you had under the governing documents as to something that you were allowed to do. And you made the decision in good faith and not for your own personal interest. Good golly, that's kind of complicated. It just means, again, don't do something if it's going to benefit you personally and it needs to be done properly at a meeting. There is this thing called indemnification. It's in the governing documents, and it's basically that if you do the business judgment, if you follow the proper business judgment rule and you end up getting sued for some reason, the association will likely indemnify you. But more importantly, and this is the advice we give anybody, make sure you have insurance. You're supposed to have a variety of insurances in an association. You're supposed to have property insurance covering the things that the declaration says should be covered. You're supposed to have liability insurance in case somebody gets injured. And then finally, you should have this thing called D&O coverage, or directors and officers coverage. Directors and officers coverage is what protects directors if they get sued for a decision. And it is very useful. You would want directors and officers coverage if you serve on a board of directors. The main obligations that I mentioned for directors are to collect the money and to enforce the restrictions. And let's break these down pretty quickly. Managers know all about collecting, so they will deal with collections. There will be a collections policy that you will sign that will say at what point do you go after people for money, how much money, how long, maybe how long and how much money. Just recognize there are a lot of notices required before you can go after somebody for collections. The manager and the law firm will take care of that. You have to do all these notices. You then file a claim of lien. There then in North Carolina has to be a resolution signed by the board that says, yes, we want to proceed with foreclosure. Then there's a notice of foreclosure. Then there's an order of foreclosure. Then there can be a sale. My theme here is twofold. One, no board member wants to go after any owner for non-payment of assessments. But occasionally it has to be done because that's the only place the association has money. There is no other place that money comes from. If you don't get assessments from an owner, it means the other owners have to pay more, or the association has to terminate services. There's just no other way that it goes forward. The other aspect of collections, again, nobody wants to do it, but if it has to be done, listen to your manager, listen to your attorney. There are lots of statutes dealing with collections, and therefore just listen to the advice of your professionals. The other thing that boards have to do, it's same in any state, Ian will hop in if it's different, is you need to enforce the governing documents, which means the declaration, the bylaws, the rules and regulations. If someone does not follow the governing documents, if they have goats in their yard when the declaration says no goats, and again, that's a document everybody agreed to when they moved into the community, there is a process which the manager can explain, and it has to do with usually sending a violation letter or violation letters before anything else is done. The owner can then be called to a hearing of the association to determine if there is a violation. If there is a violation, there are routes the association can take. In North Carolina, the owner can be fined up to $100 for a violation, and you can be fined going forward with the violation. Community privileges and services can be suspended. Ian, any major difference in South Carolina other than not being a statute to help out?
The only difference there when it comes to violations and fining is, as Jim said, we do not have a specific statute that authorizes that. So it's just going to really rely on what is in the documents. Some associations don't have to do anything. They can just fine. Some have very detailed fining process and requirements they have to go through in order to find somebody in violation and assess a fine to them. So it's just very important to go through your declaration, your bylaws, and governing documents.
As mentioned, there's a whole process to going through the violation process, and your managers know how to do that. The other thing that you're supposed to enforce is anything in the nature of new construction or modifications. If your declaration has ARC authority, or Architectural Review Committee, Architectural Review Board, if your declaration gives you the authority to ask for permission before anything is done to a property, then you should do that. The usual ARC process, which again is different per association because it's based on the documents, but usually what we see is the documents require that if an owner wants to change their property or to add an addition, they have to submit the plans. There's some deadline by which the association has to respond. Follow that. And that's because usually the documents say if you do not respond within 30 days or 60 days to a request, it is approved and there's nothing that can be done about it. So whoever is involved in ARC, in addition to the community manager, needs to be a very organized person who knows how to use calendars and puts things down and doesn't miss deadlines. If you decide not to approve an architectural request in North Carolina, and it's proper business judgment being reasonable in South Carolina as well, is you're supposed to give the reason for the denial and what could the owner do to get approval. In other words, there's a case in North Carolina, at least, that if somebody says, I want a fence, no. How about a wooden fence? No. How about a metal fence? No. How about chain link fence? No, you have to give them some guidance on what they might be able to do to get approval, because that's being reasonable. The main theme in any state with architectural things is be consistent. Everybody needs to be treated exactly the same. You don't approve Ian's request because we like Ian and Ian's on the board of directors. But you know, that Jim Slaughter, he's kind of a jerk. We're not going to approve his architect. No. Everybody needs to be treated the same. You'll hear be consistent as a theme at various times tonight, and certainly in architectural stuff, that is the case. Anything different in South Carolina as to ARC issues, Ian?
Nothing different. Just want to remind everybody that there are some associations where there's going to be architectural language in the declaration. Some of it may be vague, some is very detailed. If there is an ARC policy, perhaps, that the board has put in place, just remember, in order for that to be enforceable, it's going to need to be recorded in the state of South Carolina with your county's register of deeds. Otherwise, you're not going to have any teeth if it's not recorded.
This next slide, South Carolina is kind of quiet right now. North Carolina is not quiet. There are a lot of legislative proposals dealing with HOAs and condos. I'm just going to list a few. North Carolina has a 2-year legislative session, which means we're entering the second year of a 2-year session. Come May, the General Assembly will be back, and all of these bills are still alive, so they could easily be adopted this year. House Bill 542, which has gotten a lot of attention. We have several articles on our blogs, on our website about it. You might want to take a look at it because it would change how things are done in your association. It has already passed the House in one version. It's already passed the Senate in one version. They just didn't agree on the versions, but it has everything in it. From one of the versions of House Bill 542 would be that you could not go after people for non-payment of assessments unless they owed a certain amount of money, like $2,500, or unless they were at least a year in arrears. Another version of it that passed does not have the assessment language, but it has lots of provisions in 542. There's a provision that you would not be able to stop music lessons in any association, day or night, as long as the group is not larger than 5 students. That would make sense in a single family home association, not as much in a condominium or in a townhome where you have shared walls. It would change the law regarding what can and cannot be done on public streets. The biggest change in House Bill 542 that is still pending is it would greatly change how violations of the declaration or the bylaws or the rules and regulations are handled. It would change the law so that within so many days, a month right now, you would have to file a lien on the person's property following a hearing. Within so many other days, you would have to file a lawsuit against this owner, whether it's a big violation or whether it's a garbage can that didn't get brought in on time. You would have to file a full-fledged lawsuit. It would cap the amount of fines that any association could charge, and the number that's being tossed around is $2,500. No matter what it is, never more than $2,500. The association would not be allowed to keep that money. It'd have to be turned over to the state of North Carolina forfeiture fund, and attorney's fees would be capped at a very low figure. So no matter how big a fight, you would not be able to recover your attorney's fees. So if adopted as written, for most associations, most would say we simply don't have the funds to be able to pursue people for violations. So it could be a real concern. The Corporate Transparency Act is a federal law. It took effect January 1 of this year, and it requires that every corporation, except for charitable nonprofits, but every corporation has to file the names of those who have control over the association, board members, officers, and the manager with a federal department. It's called FinCEN. There's actually a website where that can be filed. You also have to give identification, like a driver's license or a passport. If you go onto our website, if you go on the internet and look up Corporate Transparency Act, you'll find a lot about it because it took effect January 1 of 2024. Reports are due by the end of January 2025 for any existing association. If a new association is created in 2024, you have to file the information within 90 days. So this is a thing. Some associations will start having to file this at the end of March of 2024 if they were created at the beginning of this year. For other associations, all this information will be due at the end of January 2025. If that's not enough, House Bill 3 elected created a House Select Committee on HOAs and condos, and they were tasked with looking to see what abuses boards of directors were doing to their homeowners and what bad acts were being done by associations to their homeowners and to look for remedies. You can also find information about that committee on our website. They had their first public hearing last Thursday in Raleigh. There's going to be another hearing this coming Wednesday in Raleigh where they opened it up to owners to come and voice their concerns. I will mention that last Thursday, there are 14,500 associations in North Carolina. There are 2.7 million people that live in associations in North Carolina. At the public hearing last week, 9 people had grievances against associations. So it so far has not been a huge groundswell of grievances against associations. And finally, Senate Bill 553, House Bill 551 is a landlord-tenant bill. It deals with tenants and apartments. But there's one sentence right in the middle of it that says no HOA can regulate rentals in any way. It hasn't been adopted yet. We don't know if it would be retroactive or prospective, but if adopted in its current form, it would say that homeowners associations are not allowed to regulate rentals. And so we're keeping an eye on that, and you'll also find information on that on our website. Let me give you some resources as we get into Q&A. One, absolutely, CAMS. They're the ones who did this. They put on different programs of different kinds. They know a lot of stuff about a lot of things. And so I'm giving you them as a resource because if, for instance, you wanted to have a program just on legislation, well, we could do that. If you wanted on this other thing, we could do that. If you wanted one just on how to run a meeting, we could do that. So talk to CAMS about what works and doesn't. And if you liked tonight's program, let CAMS know. Another resource is our website. We are at lawfirmcarolinas.com. There are over 500 articles on HOA condo issues in North Carolina. It's also searchable. So if you put in the word chicken, you'll find any article on chickens. If you put in fair housing, you'll find. If you put in assessments, if you put in director, you'll find articles on director duties. If you want to see our articles, and if you want to subscribe to our occasional HOA condo news update, all you have to do is take a photograph of this QR code. It will take you to our blogs. And if you read any of the blogs, it'll ask, do you want to get an occasional update on HOA condo law? And if you do, then it'll ask you if you want to subscribe to our occasional updates. And by occasional, I mean once every 2 months. But you can read the 500 plus articles on our website without subscribing to anything. But if you want to be subscribed to our occasional updates, you can do that through the website. Another website link I'll mention, we have a separate website. I do a lot of parliamentary procedure, meeting procedure. I've written 4 books on meeting procedure. And if you'd like to know more about how to run a meeting, a board meeting, a membership meeting, if you go to www.jimslaughter.com, you can also get there from our website. This is just an older site, so we kept both of them. You can find a lot of meeting procedure information. The theme I will give you is membership meetings that are big tend to be formal. Do not be formal in your board meeting. Robert's Rules of Order, which is the Parliamentary Authority for Associations, actually says that boards smaller than 12 and committees can be very informal. Just sit around a table, talk about stuff, agree on things. You don't have to pretend you're in a big meeting when you are in a small board meeting. Closing advice, rely on your professionals. Community managers are worth their weight in gold. If you have a question about something, ask. The nice thing about community managers is, again, they know when to involve us, and so rely on us. They know when to involve a CPA, but rely on your professionals. Don't act alone. Ian mentioned this earlier. We see boards most often get in trouble when a board member thinks my job is to enforce the rules, and I'm going to go talk to that homeowner. I'm going to send a letter. I'm going to call them and tell them what they do and do not need to be doing. No. As I said earlier, the board has power, but only when it meets and only when it votes. And then it tends to tell the manager to go do things. Board members acting rogue or solo almost always end up in them and often the other board members getting sued. We see it all the time. I could give you examples galore. And so act as a board, but don't act as individuals going out and doing things. And finally, after all this advice, keep your cool. That may seem like weird advice, but when we go to court for associations, the judges always, and I think Ian will agree with me in South Carolina, nod if you agree, Ian, that The judges, the clerks are always going to want to see, was the association reasonable? Did they act properly? Doesn't matter what an owner did. Doesn't matter how mean an owner was to you. Doesn't matter what an owner said to you. They're an owner. They don't have the same obligations that you do as a board member. Board members are supposed to act reasonable, and the expectation is that board members and the association will treat their members fairly and properly. So always keep that in mind. And with that, I think Ben's got some questions, and depending on where they're from, either Ian or I will answer them.
Well, Jim, thank you very much. And I'll say we refer to your website, jimslaughter.com, regularly for meeting advice. So we thank you for keeping that going. So the questions are piling up, and so we need to talk fast. But first one is probably for you, Ian. A South Carolina community, are we subject to the Freedom of Information Act?
So the South Carolina Freedom of Information Act is going to pertain mostly towards governmental entities, whether it's state, municipality, county, city, whatever it may be. That's what that's going to apply to. But just real quick, I do want to note that the South Carolina Homeowner Association Act, while it does not have a whole lot, does contain provisions in it on what documents homeowners can request from the association. So it's very important to take a look at that and see exactly what the process is for that. And there's also very common that you'll see in the bylaws that sets out processes for how homeowners can request particular documents from the association. And that kind of gives some guidance to the board on exactly the time periods and how they're supposed to turn everything over.
Same in North Carolina. There are statutes that explain what documents owners are entitled to, and there are a lot. It's just not called a Freedom of Information Act because that's a governmental thing.
Okay. Are board policies enforceable if they are not part of the covenants and or bylaws?
Yes, they are. If you keep in mind what we talked about, which is that policies tend to deal with common area. In other words, again, if the board wants to adopt something dealing with the common area, that's fine. And then, particularly with condominiums, the documents will often say what policies, procedures, rules, regulations, again, different names are used, the board can adopt. So if the declaration says the board can adopt rules and regulations regarding the size and weight of animals or dogs or the term of rentals, well, then the members, the documents, the declaration has given that authority to the board of directors. So we have to answer it carefully because, again, there are things boards can't do either. Boards normally, for instance, could not adopt a rule and regulation that no one will be allowed to rent their property. As we discussed, that's not what a policy is. That's not a rule and regulation. That is something that would go into the declaration. So we always need to know what we're talking about, but generally proper policies, rules and regulations are enforceable.
Yep. And I was just going to
South Carolina. Yeah, I was going to say a little bit different in South Carolina. Ian, where do they have to be more enforceable in South Carolina?
Yeah, I was just going to back pretty much everything Jim said there, where as long as the policies are put in place properly, based on what's allowed pursuant to the other governing documents, they're going to be enforceable if they are recorded with the county's register of deeds, because otherwise, as we've talked about multiple times tonight, they're not going to be enforceable.
Okay, the next question has to do with the Corporate Transparency Act. And I'll just say we did do a webinar on the Corporate Transparency Act about 3 months ago, so you can find it on the camsmgt.com site. There are a few questions. One about, is CAMS going to file on your behalf? And Jim,
Ben, I can't answer for you all, but I would say most of this is still in flux while we figure it out. I went onto the CinFin site last week and the site wouldn't work. None of our people could get into it. So it wasn't even live. Now it's live, but people are trying to figure out. I will warn you all, you will probably get an email that says, hey, Corporate Transparency Act, click here to file your report. Both the Bar Association and the CPAs have warned people, and the Real Estate Commission have warned people that there's this scam that's going around, where an email is going around. If you click on it, it will take you to a bad place. So just as always, exercise caution. There are bad actors already trying to take advantage of the Corporate Transparency Act, and it hasn't even been a law for more than 2 weeks yet.
Yeah, so I'll say there's a lot of unknown right now. And so we do plan on having a lot more information coming out about the Corporate Transparency Act as we learn.
And Ben, I'll add too, we're trying to get it changed at the national level, not to apply to HOAs and condos, but that has not happened yet. So again, we're hoping there may yet be some changes to this, but there will be more to come.
So who is responsible for keeping documents up to date? So if our documents are old, what do we do?
Well, there's nothing wrong with old documents. We have some associations that have really good old documents and they really haven't had to change them. Sometimes we get told or asked, hey, don't we need to change our declaration to match up with the current collection statutes? Hey, don't we need to amend our documents to match up with our current violation statutes? Well, not really, because most of the statutes that I just talked about, they override your documents. And so there are many statutes that apply to you all. May not know. That's why you should rely upon your community manager, and they can always come ask us. When someone says we have old documents, what we're more concerned about is there's something in the document you don't want there. It's no longer a right. It's not what you want. Or is there something missing from your documents that you want us to add? We're much more concerned with that than regularly we get asked, hey, don't you want to update our documents? And our answer would be not unless something needs to be changed, because amending the declaration is a lengthy, time-consuming, expensive process, and it may not pass if it's just to update the documents. There has to be something in there people care about. On the other hand, I will say we regularly amend bylaws because old bylaws tend to be bad bylaws. And so we'd be happy to take a look at any. Those can usually be done pretty quickly. HOA bylaws aren't even filed usually with any entity, and it's much cheaper to amend bylaws than it is to amend a declaration. So we'd be happy to look at any documents, but you don't have to amend old documents. It depends on what's in them.
Okay. Are fines considered dues?
Ian, you want to answer that since you do a lot of that in both states?
So the answer is yes and no. So they're not considered dues in the same way that annual assessments would be. But that being said, most of the declarations or the governing documents that actually talk about the collection of assessments and how to proceed with delinquencies, the fines are going to be treated the same way as those assessments are. So you would follow through the same collection process, the claim of lien, the foreclosures, and all of that. So in essence, they're treated the same as dues, but they're not dues because they're not getting assessed to every single owner every year.
Okay, so I know I said I was going to try and hold y'all to 5:30. We have about 25 questions lingering.
Up to you, Ben. Up to you.
Well,
I can stick around.
We can go another 15 minutes and try and get through as many questions as we can. I'll say for those of you that need to leave, please feel free to do so. But we will continue answering a couple of questions up until about 5:45. So I will try and talk quick.
Ian and I will try to answer quickly. We won't use any adjectives.
Okay. Can board members be personally sued if they make a bad judgment call?
Yes, board members can be sued when they make a correct judgment call. Anybody can be sued for anything. Protect yourself by doing what we talked about in terms of making decisions, and make sure you have the proper insurance coverage to protect yourself in the event you get sued.
Act in good faith and do what you believe is the best interest of the association. That'll help you protect yourself.
But as you mentioned, there are protections in place for board members through statute and other means.
That is correct.
Who can make changes to rules and regulations, the board or homeowners?
Usually the board. And that's because, again, we talked about this, so I don't want to beat a dead horse here, but if the rule and regulation is something dealing with the common area, that is within the purview of the board. If you're going to amend the declaration, that's going to involve the members. And in fact, there's a state statute that says that's a supermajority vote. If you're going to amend the bylaws, that's also a vote that's going to be governed by what the documents say. But if we're just talking about a proper rule and regulation, that's normally board adopted. Is it ever different? Yes, we have some associations where their documents say that the rules and regulations or the policy have to be voted on by the members, but that's because the document says it. So there's a little bit of it depends to our answer.
Okay. Is there a federal law regarding how much a homeowner owes in assessments before a South Carolina judge will force a homeowner to pay what they owe?
No, there is not. There's not a specific amount that a homeowner has to owe in order for you to proceed with the collection process. In fact, we typically will tell associations, even though it may seem like a small amount, it's a lot easier to pursue collections on a delinquency because one, it's more likely that the homeowner is going to be able to pay the smaller amount than if you let that accrue over time. And two, at the end of the day, as a board of directors, your job is to make sure that you're collecting all the funds that the association can in order to pay for everything that you guys need to get done in the association.
And I feel an obligation to at least mention, sometimes we get asked, shouldn't there be a dollar cap, $2,000, $5,000 before someone can be gone after for assessments? Keep in mind, associations are very different. We have downtown big city condos that might charge $1,500, $2,000 a month in assessments, but we also have associations that don't have a lot of amenities that charge $150 a year, $150. And so if you had to wait until that association runs up a $1,000, $2,000 assessment, you could be talking 5 or 10 years before you would go after the person. And yet that association also has obligations, and that money is just as important to those homeowners as it is to the wealthier association. And so you might well just be punishing associations that don't have as much in the way of assessments because they're going to have to get that money from the other homeowners because their bills did not go away.
So does one board member have greater authority than another, such as the president?
And in fact, except as your documents might provide, even the officers, unless the documents describe it differently, officers are people who have certain roles. The president runs the meeting, the secretary keeps the minutes, the treasurer watches the books. But if they are board members, in terms of their real power, they only have the power that the documents give them, or they only have the power as a director. And at the end of the day, again, as we discussed, directors individually, no power. Directors collectively govern the association, but it should be done by the board making a decision and not by individual directors deciding what they think is best to be done for the association.
Do I have to document my recusal from a particular vote?
Document my recusal. Well, you can. It normally would not be in the minutes, but if you wished it to be in the minutes, you could actually say, and you'll see this with school boards and county commissions and city councils sometimes, it will be in there that Ben Rhodes recused himself from the discussion and the vote because his relative works for the landscaping company or something like that. That is perfectly fine. It's more important that you do it.
So you've talked a little bit about declarations, changing the declaration and changing board policy. How about changing your bylaws and in articles of incorporation? Who gets to make those changes?
That's based on the documents. And Ian can say if it's different in South Carolina, but in North Carolina, the statutes say that the bylaws are supposed to say how they are to be amended. It's usually easier than for a declaration. Declaration is a supermajority vote of all the lots. Usually bylaws can be amended at a meeting, often by a 2/3 vote, but sometimes it's at a meeting by a majority vote. Sometimes it's higher. It's what the documents say. Same with the articles of incorporation. What do the documents say? If the documents don't say anything, there is a statutory default in North Carolina as to how you can amend bylaws and how you can amend articles of incorporation, but usually the members are involved in the votes on both of those. Ian, any different in South Carolina?
No, it's the same in South Carolina. It's going to depend on what the documents say and what the percentages of the membership that need to approve any kind of changes through a vote. And again, if there's not any language, there is some in the South Carolina Nonprofit Act that can address that. It's just not particularly tailored towards HOAs, just nonprofits as a whole, but that still gives us some guidance in the event there isn't any amendment provisions in them.
What happens if no one wants to be on the board?
That's a bad thing. The association, the corporate entity does not go away simply because people don't want to be on the board. There is a process. If an association of a planned community of condominium truly is like, look, we don't even need this darn association. We want to dissolve it. There's a process for terminating an association. We don't see that very often because, again, if you terminate it, everything goes away. I mean, the property restrictions, people can have goats, all of a sudden anybody can do what they want. There's no money being collected to pay for the common area or other items. And so we would, along with the manager, if it's difficult to get a team together to be directors, we would actually have a discussion with the existing board and we would encourage them to recruit people to run for the board. We sometimes have had meetings to discuss how important it is. I mean, if you don't have an association board and the association gets sued, or if the state stormwater people send a notice, or if something happens from the state revenue department, there's nobody to respond to that. And bad things can happen to the association and to the homeowners within the association. This is the kind of thing that can affect property values and make them go down. So we would have a discussion of trying to get people to agree to step up and serve on the board of directors.
Can a board of director or can a director be voted out by a majority of the directors?
Only if the documents allow it. The state statute in North Carolina provides that the members remove the directors. If the members elected the directors, normally the members are the ones who can remove the directors, but sometimes documents are drafted differently. But that is what we see all the time, is that the members are involved in the removal of a director. Sometimes the documents will have language that if a director misses so many meetings, they're automatically off. That's a little different. If you want to remove them for some sort of conduct, that tends to always go back to the members. Any different in South Carolina, Ian?
No, it's very much the same. There, of course, is times when there's language in the declaration or the bylaws that provides for different avenues that the board can take to remove board members. But ultimately, typically, it is membership elects directors, directors elect the officers.
So Ian, you made a comment earlier, and I thought there may be a question coming from it, but you mentioned earlier that board members cannot elect new board members. How are board positions filled that are vacated before the term is up?
Yep, that's a great question. I get it quite frequently. Those are two different things there. So what I meant when I said that board of directors cannot elect other members to the board, it's that you can't go to an election and just place somebody on the board there. If there is a spot that has come up and the term is finalized, to fill that spot, the membership is going to have to elect an individual to serve in that position. However, if a spot gets vacated, let's say that election takes place and 3 months down the road, the person who's elected to the board steps away and resigns, then the board can appoint somebody, usually depending on the documents, can appoint someone to serve out the rest of that term. So they can't put somebody in there initially to run the entire term, but they can fill vacancies.
Okay. Jim, I think you made a comment earlier about the only way to get income was from dues or assessments. Some associations have other sources of income with non-assessment revenue or donations. Is that legal? And can you recognize somebody if they give to the community?
Well, I'd want more information, but at the end of the day, an association is a nonprofit, meaning that it doesn't make money. All of the money that comes in under the declaration is earmarked for something. It's either needed now or it's being put aside for reserve. I'm not sure of this concept of people voluntarily donating more money to their associations, because Ian may know about that in South Carolina, but we don't tend to see voluntary donations to an association. A declaration sometimes will have specific charges for certain things just for the administrative costs. But the way the statutes are in North Carolina, you really don't get any money in an association except what's paid through the assessments. Of course, it could be regular assessments. It could be a special assessment. And if you don't get the necessary funds, almost always the consequence is you have to reduce services, because again, it's a money in, money out. We just collect the money and then give it to the power company or to the sewer company or to somebody else. It's not really like we can make more widgets as a company might do. Ian, you got any idea what this voluntary contributions to assistant association is?
No, it's I agree with everything you said there, Jim. The donation may seem nice and it may be very helpful for the association to have, particularly based on the question, a new bench or something along those lines. But at the end of the day, you're not going to be able to use that bench to pay the lawn vendor or to pay the power company or anything like that. So it's not going to be able to be substituted in or out or anything like that.
Even reserves, particularly in condominiums, we sometimes have it asked, can't you live off the reserves? Well, not to pay current bills. That's not what the reserves are for. The reserves are earmarked for certain future needs, like a condominium at the coast might have an elevator, or it might have certain piers or walls or docks that need to be maintained, or even just the painting of the exteriors or replacing the roofs. The idea of that little bit of extra money that everybody pays is it's going into a reserve so that 5 or 10 years from now, we then have enough money to replace the roofs. But in theory, all the money in an association is earmarked for a specific thing, and that's the way the statute is written as well.
And it's very common that the declaration will lay out exactly what that money is to be used for as well, whether it's annual assessments or reserves. They may have exactly what those funds can go to. So if you use them in a different manner than what's laid out in the documents, you're not following the rules and restrictions yourself.
Okay, if there have been approvals of architectural applications that are outside the guidelines made by other boards, is the new board bound by those decisions, or can the new board go back to the guidelines and enforce them?
Ian and I can give a definitive legal answer to that one because it depends. And the reason it depends is we just don't have enough information. If someone does something, builds something, and it's in violation of the declaration, the declaration says there shall be no chain link fences, and somebody puts up a chain link fence. Heck, the association might not even have to do anything because other owners could go after that because it's a violation of the declaration. The declaration says you can't do that. That's different, though, than architectural guidelines. If the architectural guidelines say, we prefer white paint, and somebody submits and either the architectural committee never responds, and so they paint it white, or they paint it white and it's been white now for 10 years, that ship has probably sailed, but we would want more information about the specifics. We just don't have enough information from that question to know exactly what's going on.
Okay.
Yeah, absolutely. Definitely need the more information to be able to give a concrete, definitive answer. But at the end of the day, ARC guidelines typically can be changed. They kind of fall into that board policy avenue. And as new people serve on the ARC or serve on the board, they may have different opinions on what they think looks better for the association. So guidelines can change, and those guidelines can change over time. So what may not have been approved by this ARC may get approved by 10 years down the road.
Mm-hmm.
So that kind of segues into the next question. Do we need to record our ARC guidelines in North Carolina, or does it need to be voted by the members, or can it just be done by the board?
Well, associations in North Carolina only have such architectural control as is given to them in the documents. So then you would do what the documents say. Normally, architectural guidelines are not recorded, and most associations would not want to because that would fix them too much. I mean, you're likely to make an error or to be too specific with your wording, and then you wouldn't be able to modify it. As Ian said a few minutes ago, architectural committees often have pretty broad authority as to what can and cannot be done, and it's better to do it that way.
Okay. How often can a board member miss a board meeting or town meeting with all of the owners?
And I'm sorry, how often can they miss? Can
they miss a meeting?
I guess the answer would be all of them, but that would be a very bad board member. There is no statutory requirement that a board member attends so many meetings, but some documents say if you miss so many meetings, you're off. And as we mentioned earlier, there is a statute that deals with how you remove board members. And one reason to remove a board member might be they're not doing what they're supposed to be doing, which is going to board meetings. So that might well lead to a removal meeting. I don't know, in South Carolina, is there any requirement as to a number of meetings a board member must attend or else?
No, there's not a requirement on how many they have to attend, but there is sometimes in the actual governing documents, it says if you miss so many meetings, the board member will be removed from the board. And I've also worked with associations where we have done board member code of ethics, where it lays out basically all of the responsibilities that you may have to deal with as a board member. And you agree that if you violate any of those, you will resign from the board. And often one of those requirements that's laid out in there is, I have to attend a certain percentage of all of the meetings.
Having given the legal answer, going to board meetings is about what board members have to do. So if lots of meetings are being missed at the board, that member should probably consider resigning from the board, because it sounds like they have some sort of a personal or work commitment that is keeping them from fulfilling their duties. Of course, remember that boards now, and even for some time, can meet in person, can meet virtually, can meet by telephone, can meet in person, and someone is virtual or on telephone. So it really shouldn't be that complicated for a board member to participate if they wish to participate.
Okay, I'm going to ask two more questions, and we're just over a little, but is there a definition by code or Black's law for offensive, something that would define offensive?
There is not that would apply in all situations. The Black's Law Dictionary is a dictionary of law. There's one I could pull out off the shelf over there. It's very big, it's very thick, lots of words in it, and it's a guide to things in various states. But there is no specific definition of offensive, which is why one of the biggest things Ian and I would recommend is declarations are supposed to be clear. They're not supposed to be capable of two interpretations, and they should be very definitive in their wording. Older declarations sometimes were like 4 pages long. Current declarations tend to be more like 40 pages, but we have declarations that are 125 pages or longer. And that's because they're trying to be very precise with their wording. Old declarations would say you were only allowed to have household pets. That's not sufficient anymore. If you want to allow certain animals, not allow certain other animals, you ought to list exactly what those animals are. You ought to say, there shall be no fowl, poultry, ducks, chickens, birds. List the whole thing, because then there's no room for interpretation. And that's the problem with a word like offensive is, your grass height, Ben, is offensive to me. What the heck does that mean? It's too broad a word. So we don't like that word by itself. It's the same as nuisance. Nuisance is a very broad word. We'd like to see more.
Okay, last question, and I'm sorry I haven't been able to answer or ask everything, but do members have the right to attend board meetings?
And I'll let Ian answer for South Carolina first, and then I'll take North Carolina.
Right. So board membership, regular members of an association do have a right to attend board meetings. And we usually do advise that you hold open board meetings. That being said, there are times when you have to have conversations that not everybody can be privy to, whether you're talking about legal action, collections, as Jim was talking about earlier, or just other executive sessions that the board is going to have to close up. We very often will advise that you do have open board meetings so that members feel included and they don't feel like the board is doing anything in secret. But at times there are going to be meetings that need to be done strictly with the board members and don't necessarily even need to be advertised per se.
And in North Carolina, there is a statute that says on a regular basis, board meetings are supposed to be open so that members can come and voice their concerns. We encourage boards to be open because when possible, it's just best to be transparent, let everybody see what's going on. But as Ian mentioned, occasionally you're talking about things at the board meeting that it would not be appropriate to discuss in an open session. For instance, someone's falling behind in their assessments. What are you going to do with them? That's usually done not in an open session. Someone is being accused of having violated the governing documents, and we may start a process against them. That doesn't need to be talked about in public. Let's talk with the lawyer about their opinion on something like an insurance issue. That should not be talked about in open. So occasionally the board is going to need to meet in closed session, but we do encourage when possible that boards be open. Ben mentioned we're going to be wrapping this up. I will mention again, we have like 500 plus articles on our website. If we didn't hit your topic, if you go to www.lawfirmcarolinas to the blogs, you can probably enter the word and you will likely find something. We encourage all of our attorneys to write articles that are suitable for public consumption, and they are available for anybody to read. And before Ben wraps this up, I want to start the same way, or in the same way we started. Ian and I were happy to be with you tonight. We really have a lot of respect for board members. Associations would not work, but for the time and the commitment that you're giving to help the association be a better place. So thank you very much for your service.
Yes, and thank you all. 69 individuals stayed with us to the end. So we do appreciate your time this evening. As a reminder, we did record the session. And if you would like to watch it again or share it with any of your other board members, you can find that at camsmgt.com. It will be posted probably by Monday next week. So again, thank you, Jim. Thank you, Ian, and look forward to seeing you next time. Good night.
Thank you all.